This material is made available to you by or on behalf of the University of Melbourne under Section 113P of the Copyright Act 1968. It may be subject to copyright. For more information, visit the University Copyright website.
Can I start by saying that we meet tonight on the lands of the Wurundjeri people of the Kulin Nation and pay my respects to their elders past and present, and also my respects to any Indigenous people who have joined us for this evening's lecture. Good evening, distinguished guests, ladies and gentlemen. I'll start by introducing myself. I'm Pip Nicholson, the Dean of the Law School, and it is a particular pleasure to welcome you all to the 2019 Peter Brett Memorial Lecture. I'd particularly like to acknowledge the presence of the Brett family. Thank you all for joining us tonight. I would also like to thank our distinguished guests and, of course, in particular, our guest speaker, the Honourable James Wood, AOQC, Chairman of the New South Wales State Parole Authority, which keeps him extraordinarily busy, I've just been hearing, and also of the New South Wales Sentencing Council. So welcome, Sir James. I'd also like to acknowledge that Professor Jack Anderson had played quite a role in tonight's lecture. He will chair the questions afterwards. He is the Director of Sports Law at the Melbourne Law School, and I'll make a few introductory remarks about Jack in a moment. For those of you who don't know, Jack's coming up to the 2-year tenure of his role here at the Law School, and we're delighted to have the lecture in some ways to celebrate that moment in the Law School's sports law program development. I've got a few comments by way of housekeeping, and the first is this is the moment to turn off your mobile phone if you haven't already done so. I will shortly check my handbag to make sure that I'm compliant with my own instructions, so please do turn off your phone. All the more so because we will be taping this evening's proceedings so that they can go up on the website shortly after, or in the coming days at least, for the benefit of the broader public. Photographs will be taken from time to time, and if you're uncomfortable with that, just let the photographer know and we can make sure that those photographs of you are not uploaded. Tonight's lecture forms part of the Peter Brett Lecture Series. The late Peter Brett was appointed Senior Lecturer at the Law School in 1955. He became a reader in 1961 and the Hearn Professor of Law at the University of Melbourne in 1963 to 1964, and Professor of Jurisprudence from 1964 until his death. I have always felt an affinity with Peter Brett. The year in which he was appointed the Hearn Professor of Law was the year in which, well, 64, the second of those years, was the year in which I was born, and I am today the Law School's Hearn Professor of Law, and so there's some symmetry in the type of recognition that the Law School extended to him, as it has kindly done to me, but I would not lay claim to have made the contributions to law that the late Peter Brett certainly did. He was an extraordinarily distinguished scholar in criminal law and legal philosophy, and his determination to test injustice in the courts is very widely known. So it's also fitting tonight, Sir James, that the lecture will review criminality and corruption in sport. We see a great continuation of Peter Brett's legacy through your contribution to the series tonight. Let me make a few comments about sports law and then a few comments by way of introduction to Sir James. Thanks to the vision of Hayden Opie, who is known to very many of you in the room tonight, Melbourne Law School was a pioneer in the field of sports law. And I think we can say with some modesty, but also with some pride, that it remains a leader in the area of sports law. And one of the particular joys we take is that our alumni work at the highest level of sport in Melbourne, nationally and internationally. So I just want to pay tribute to Hayden as the founder of the Sports Law program, and also to celebrate 2 years of sports law under the leadership of Jack. We've got a range of programs being offered in the subjects being offered in the sports law program currently. I'm not going to go into details because I stand between you and a fascinating lecture, but sports medicine and the law will be offered this year, and a range of other subjects, including sports integrity investigations, sports governance and eSports law. I would now like to move to introduce tonight's lecture, which will be delivered by the Honourable James Wood, AOQC, Chairman of the New South Wales State Parole Authority, as I've already mentioned, and the New South Wales Sentencing Council. Justice Wood was appointed Judge of the Supreme Court of New South Wales in 1984 and became the Chief Judge at Common Law in 1998 before retiring in 2005. During his time as a judge, he conducted a Royal Commission into Corruption within the New South Wales Police Force. He also served as a non-resident judge of the Fiji Court of Appeal between 2004 and 2006. Justice Wood served as chairman of the Law Reform Commission of New South Wales between 2006 and 2014. In 2008, he conducted the Special Commission of Inquiry into Child Protection Services in New South Wales. As lead commissioner, James Wood drafted the New South Wales Law Reform Commission's 2011 report on cheating at gambling. In 2012, he was commissioned by the Minister for Sport to conduct a review into the governance and anti-doping arrangements of Cycling Australia. In 2018, Mr Wood led an independent expert panel supported by Mr David Howman and Ray Marihi, which presented the Australian Government with a report on the review of Australia's sports integrity arrangements. The review addressed key domestic and international threats to the integrity of Australian sport and made 52 recommendations across 5 key themes, and included recommendation to establish a national sports tribunal. Justice Wood has a formidable record of social service and contribution to improving and reforming the law itself and the institutions that sit behind it and are such a critical part of the implementation of the principles that we as a community aspire to see reflected across police, law reform and including in sports arrangements. And we very much look forward to your lecture tonight, Sir James. Thank you.
Well, thank you for that introduction. May I also pay my respects to the traditional owners of the lands on which we are gathered and to their elders past and present. It's my distinct privilege to be able to present an address in the course of the Peter Brett Memorial Lecture Series. I have had a look at some of the past presentations, and I must say I feel somewhat humbled by being able to join that group. It is true that I have been engaged in other Royal Commission type investigations, and I was asked if I might possibly draw on my earlier experience in relation to some of those inquiries. Of course, they're all very different. As was pointed out, I was engaged in the Royal Commission inquiry into the New South Wales Police Force, the inquiry into the Child Protection System, Cycling Australia, the Customs Reform Board, and also this most recent review. As I said, they're all very different types of inquiry, but I think I've learned a lot from the way they were structured and what the challenges of them were. They took different forms. The Royal Commission into Police was really a law enforcement task. We were established with teams of lawyers, police investigators seconded from the other states and territories, intelligence analysts, and also a surveillance team which was able to carry out interceptions of various kinds, tracking devices, listening device work and so on. And we were targeting actually both criminals who were doing the corrupting and also the police who were corrupted. We carried out our work, therefore, in an investigative phase, but the exposure of what we found came out through public hearings, where, of course, those who were affected were entitled to be represented. Now, there have been many complaints or suggestions in recent years that Royal Commissions should not conduct their work in public. But I utterly reject that, because it's the only way that you can collect further information from people who see what is going on and also expose the extent and nature of the corruption. The other inquiries are somewhat different. The child protection one we carried out through public hearings across the state, first of all with panel meetings in bringing people together from all of the interested agencies, but then in the country in particular, inviting people who have been subject to removal from home, who had been caught up in the protection system, who had had trouble with reporting requirements and so on, to get their impressions. The other two inquiries, the Cycling Australia and, of course, this current one, were very much review on the material and with interviews of those involved. The Customs Reform Board one was quite interesting, and again, like this current inquiry, it brought together expertise from other sources. I was joined on that inquiry by former Police Commissioner in New South Wales, Ken Moroney, and also by a member, David Mortimer, who had been a director of TNT of the Airports Corporation and had a huge experience in moving goods, equipment and so on. That, to my mind, was a fascinating experience, because we were investigating corruption within the Customs border force, particularly at the airports and the seaports. The challenge, of course, for Customs in that area is enormous, because of the nature of it and size of our boundaries, the volume of goods that move in and out, and the volume of people that move in and out. But again, I thought that experience was important, because it indicated the need for these inquiries to have a range of expertise, and if you can actually get people from different walks with cross-expertise and experience, it really does work. Well, can I move on then for tonight? But I will say, before I start from that, there are some obvious overlaps. Each of the inquiries focused on vulnerabilities. We had to deal with resisting the pushback from those who were involved, including from the police, who are subject, of course, to the traditional culture of the blue line culture, but also the opposition of all of those agencies to ceding control to any outside authority. We face silo issues, especially in the child protection and the sports integrity area, because information is held by a number of different people in different places. With the child protection inquiry, I was somewhat surprised at one stage in a country hearing where we had people from all of the relevant agencies there, health, education, police, disability services and so on, that not one of the senior officers who were at that meeting had ever spoken or dealt with their counterparts. And you cannot run the child protection system unless you have everybody talking to one another on the same page. And this is the same thing we found in relation to sports integrity, with the various agencies involved from different quarters who simply have to work together. But I will come to that. But I suppose the initial question one must ask is, does sports integrity matter? Well, the answer to that, I think, has to be a resounding yes. Sport now, by reason of the commercialisation and the professionalisation, does occupy a significant part of the economy in the opportunities it provides for the employment of athletes and their entourage, on the support it provides for the media and entertainment industries, for the wagering industry, for gambling opportunities, and for those who obviously manufacture sporting goods. I am reluctant to quote figures about which I have no ability to test them, but a critical factor, I think, is that the recently released National Sports Plan, Sports 2030, recorded that sport in Australia delivers some $83 billion in combined economic, health and education benefits each year, a return of $7 for every dollar invested. It also noted that 14 million people in this country participate in sport annually, with 220,000 people directly employed across the country, helping to generate almost 3% of the national GDP. Taking but one sport of interest, I was informed recently at a meeting in Sydney that the AFL now hosts 18 national teams, has 1.6 million participants, 10,000 registered officials, with $7.6 million attendance per year, with an estimated annual wagering turnover from all licensed Australian bookmakers, and that's leaving aside the unlicensed illegal ones, of about $1.8 billion, and an average turnover of $8.1 million per match. And that's in 2018. The figures for the regulated Australian sports betting market are $10.1 billion in turnover on a strong year-to-year growth, the growth from 2015-16 having been approximately 35%. Now, those figures do not take into account the bets placed offshore with unregulated or partially regulated bookmakers who operate substantially but not exclusively in the Asian region and who employ decentralised wagering platforms that are pretty much beyond traditional regulation. Those figures, of course, are totally dwarfed by what is happening on the international market, and particularly unregulated illegal market, but estimates place that overseas sports betting market well in excess of $1 trillion US dollars per year. However, that may be, it is the very size of that sports market and of the sports wagering industry that has attracted the attention of organised crime, particularly overseas, and has ignited the concern of the Australian law enforcement agencies and of their overseas counterparts. Where the money goes, of course, there goes organised crime, not only in fixing matches in support of betting, but also in operating illegal betting sites and in engaging in the supply of illegal drugs and performance-enhancing drugs, because those two do go hand in hand, particularly where the OCMGs are involved. The outlaw motorcycle gangs are involved. The interests of organised crime in this area, of course, extend well beyond the simple area of betting, whether providing the betting service or fixing bets, because it extends also to the fact that their work in this field does help fund their money laundering activities and their other illegal activities in relation to drug dealing, terrorism and arms sales. It doesn't even stop there, because international experience has shown that organised crime is becoming involved in the purchasing or franchising of sporting clubs, the manipulation of sports management and procurement contracts, and also, it's been alleged recently, even in the involvement in human trafficking through the offer of sponsorship to people, particularly in the African continent. Now, to the threats that are involved in relation to betting-related match manipulation, I will return, but it is important to note that our review recognised that sports integrity doesn't stop there, because it extends to health and safety issues relating to protection of participants, particularly from younger participants from sexual and physical abuse. It extends to racial, religious, sexual vilification issues, classification and selection issues, salary cap breaches, data and court-siding issues, and also something which does, I suppose, attract my interest, namely the lack of support that's been given to professional sportsmen at their retirement stage. And we've seen in this area a huge number of mental health breakdowns, suicides and so on, and I fear that sports for some years and some time really has ignored the responsibility it must have to look after those sportsmen who are coming to the end of their careers. In any event, as I say, our review focused very much on the consequences of manipulation and corruption in sport because of the loss of confidence, credibility and respect that creates for the sport, and its threat to its commercial viability. A prime example, of course, in this area was the Taiwan Professional Basketball League, which in the 1990s became involved in rampant match fixing, which led to plummeting attendance and eventually to disbandment for a number of teams. It also risks devaluing the importance and the contribution of a sport in the international area. The Australian government has recognised that through a sports diplomacy strategy, and that strategy is designed to build partnerships in our region to promote effective governance and integrity, and if that is affected by a lack of reputation on our part through rampant or systemic corruption, then that is seriously damaged. I just go on to sports manipulation through match fixing because, given the constraints of time and the topic of the paper, I really must concentrate on that tonight, although I would have liked to say something more about the anti-doping response, which is also significantly important in this area. Cheating driven by betting has been observed to be actually a bigger threat to sport after doping, but I would somehow wonder whether it's not now ahead of the doping threat, particularly having regard to some of the recent cases which we have seen, some of which I will refer to. So match fixing can take several forms that involve players, coaches, managers, support staff, match officials, venue staff and others, as well as those who recruit members to place bets and to fix a match. I probably will be going over ground that those who are involved in this area know very much about, but for those who are perhaps not, would you forgive me if I explain that the match fixing can obviously relate to the outcome of a match or outcomes at various points, half-time, quarter-time, so on. It can relate to points, spreads between the two sides, which are obviously able to be manipulated through point shaving. It can also relate to a contingency within the event, such as the nature of the first score, the number of goals scored, the number of penalties awarded, whether no balls will be bowled in a given time, and so on. So we are looking at match fixing relating both to outcomes and also as to contingencies or events within the game. Match fixing is most commonly related, obviously, to betting-related match fixing, but it isn't confined to that because it also extends to what has been referred to as sports advantage fixing. This involves a deliberate underperformance or withdrawal, often referred as tanking, which is designed to secure for a team or a participant some advantage in their sport. It may be done to secure a more favourable position in a pool or draw, as was seen in the Olympics, in London Olympics with some teams. It could be done to avoid relegation or to secure promotion. It could be done to retain a position at the end of or bottom of a league table so as to get a better result in the end of season draw. It can be done to preserve sponsorship or to share prize money and so on. There are many reasons why people will engage in match fixing outside the betting-related fixing. The vice, of course, is that it has an impact on those people, spectators or punters, who have come to the game or put bets on it in the expectation that it is a fair match. It is also unfair to those who have set a market on the basis of what is predicted to be a genuine contest. The other advice is that once someone gets a taste of this for their own advantage, it's a very easy step to be manipulated into a match-fixing, betting-related sting. That is either because they found it so easy to fix the event, but more importantly, often they are compromised and are vulnerable to organised crime approach. The extension of criminal liability to match fixing, which is unrelated to wagering, was foreshadowed in the 2014 Council of Europe Convention on the Manipulation of Sports Competitions, the McCollum Convention, and its criminalisation has been recommended in the United Nations Office for Drugs and Corruption criminal law provisions. A number of countries have followed that course, but it is only in Australia that the Queensland legislation would be capable of extending to match fixing, which is unrelated to betting. So then turning to betting-related match fixing, obviously this is an area for organised crime to involve itself because of the potential for high profit and low risk activities, particularly when it's carried out through online betting through unregulated or illegal operators, because there's a high degree of anonymity involved on both sides of the transaction and a consequent limited exposure to the criminal law. The Australian Crime and Intelligence Commission and the overseas counterparts have been working very closely and extensively in this area, and that has revealed the systemic presence of organised crime in match fixing in a number of places. Organised crime has the benefit of using tax havens, their experience in working online, employing the dark net and cryptocurrencies, but also using the complex master agent and sub-agent structures which are available to move monies that is employed for this kind of activity. Indeed, some of the online people have even created their own own sports betting specific cryptocurrencies. For example, one which is called casino tokens. The vulnerability of athletes to being caught up in this area obviously arises through grooming. That this is the case has been seen by through the regular associations that have been observed between criminals and sportsmen, sports agents and bookmakers, that has not escaped the notice of the media or the clubs or law enforcement, but it seems to have involved a somewhat natural symbiosis. The grooming process obviously follows a trodden path. It begins with a meeting, followed by a friendship in which vulnerabilities are detected, then a payment of a gift in return for a small favour, and finally entrapment into a fixed. The vulnerabilities are well recognisable and they can be self-regulated or brought about by outside influences. Those who are particularly at risk include sportsmen and others who have built up unmanageable gambling debts, have been supplied with performance-enhancing or illicit drugs, or who need financial support to sustain a fledgling or flagging sports career, or find that their salaries have become the responsibility of organised crime syndicates that have purchased their club and they are not being paid, or those who wish to have personal indiscretions concealed. Once ensnared, of course, organised crime has no compunction in using the traditional weapons of blackmail, bribery, intimidation, assault, extortion and so on to force continued participation and concealment. What needs to be recognised is that match fixing is not confined to the major events or to events at First Division level. There are any number of examples of fixing occurring at lower levels, as was the case with the Southern Stars case in the Victorian Premier League that involved some players who had been brought in from overseas. Amateur and junior events have been attacked, as have demonstration events where the overall result is of no moment, when there's likely to be limited public interest or public profile. One of the real challenges, I think has been mentioned, arises from the online use of betting, which is occurring rather than through the traditional land-based retail outlets. This has opened up a huge number of opportunities for match fixing or fraudulent activity, and the advantages both for gamblers and wagering providers are not insignificant. The odds on offer, particularly where the product has been offered from, say, Asia or some unregulated provider, they're likely to be better because the offshore provider does not pay Australian income tax, licensing or registration fees. The offshore providers tend not to place betting limits on people or to refuse service to successful gamblers. The nature of the service, being online, provides a greater degree of anonymity. In Australia, clearly a very large part of the sports gambling does occur online, but not the in-play online gambling. That is at the moment still unlawful in this country. It's a matter that we looked at in the O'Farrell, and also the O'Farrell report, which previously looked at online gambling, raises a possibility for future consideration. It is interesting that there is no restriction in Australia on betting in play online on racing or on placing a local bet by a live voice call, and it is also not banned in UK or New Zealand. Recent efforts have been made by ACMA to address this issue, that is particularly the issue which arises where so much of these bets are placed online with overseas unregulated or illegal wagering providers, through the Interactive Gambling Task Force. They have been working with the overseas regulators and seeking their assistance in warning providers to not offer their services in this country. It is, of course, illegal for an unlicensed, unregulated wagering provider to operate in this country. Other measures have been tried to discourage the activity of the offshore, illegal, unregulated providers through targeting credit betting, blocking monetary transfers, blocking ISPs, pop-up warnings, cancelling visas, or placing people on movement alerts, but these have been of some limited value. The other area which is of concern in relation to the online activities, of course, has been the emergence of fictitious and ghost events. There are a number of operators who are offering markets on fictitious or ghost events in which there is an obvious capacity to manipulate the outcome to the detriment of those who place the bet. And although these activities do not involve live participants, they are of a real concern. If I can turn to eSports, and I'm really pleased to hear that eSports will be part of the curriculum next year, but this evolution in eSport has been quite enormous, and its estimated global market has been assessed now to be well in excess of $1 billion. These contests obviously are taking place online between individual competitors or teams, and they now have presence on local TV, as I've noticed recently. When played in auditoriums, they're attracting enormous crowds with, I suppose, the atmosphere of a rock concert, with flashing lights, loud music, and so on. eSports has been accepted for the Asian Games. It's been knocking on the door for the Olympic Games, but that, I think, is a step too far. But there are a number of issues in this area, because there's also significant betting opportunities now available. These events clearly are ripe for match fixing, particularly for betting, and they are vulnerable in a way which is unique through the capacity for hacking and manipulation through slowing down or disabling a participant's response when an activity is occurring through a computer. The fact that while Australia now has an eSports Integrity Commission and a Code of Conduct, there is as yet no international governing federation. Next, an issue is the fact that the individual sports are owned by their designers or publishers, and they have no particular reason to cede control or to enter into integrity agreements. There is a lack of government involvement because sponsorship or funding from government is not a reality in this area. These activities are supported by crowdfunding, ticket and product sales, sponsorship, and so on. They, as I say, what is interesting, I think, is they offer significant prize monies for the major contests, particularly such as the League of Legends, and they are now supported by many professional AFL and football clubs who have established their own teams under their own banner. Recently, I noticed there's a Meta High School eSports League competition has been established, which is apparently run by the Adelaide Crows and the game publisher, and there are some 160 schools or thereabouts involved across Australia and New Zealand. So I think for any new legislation of the kind that we were considering in this report, is going to have to make sure it catches eSports. Otherwise, there may be some criminal response available through the normal computer crime legislation, but it's not going to assist so far as manipulation to aid a sports bet. Law enforcement issues, and this is really where I came into this area, because I entered the field back in 2010 following the Ryan Tandy NRL case. You may recall that was a case where there was a pre-arranged fix in support of a bet that the first score in the match would be a goal scored from a penalty. Tandy gave away a penalty early in the game that provided an easy kick for goal. However, the plan didn't go as expected because the opposition took a tap and the first score became a try. At that time, I was the chairman of the New South Wales Law Reform Commission, and being interested in sports, I managed to persuade our Attorney General to give us a reference, because it was clear there were many other people than Tandy involved in that potential sting, and because I thought that the traditional fraud of offence of obtained financial advantage by deception really was not well adapted to purpose. So we managed to get that reference, and that led to the Law Reform Commission's report, Cheating at Gambling, and to the enactment of a number of offences. In summary, those offences, which are now contained in the Crimes Act, apply only to cases where betting is lawful according to New South Wales law, but they include offences of engaging in conduct that corrupts the betting outcome of an event or event contingencies, facilitating conduct of that kind, encouraging another to conceal the conduct, the use of corrupt conduct information, and the use of inside information. And these offences apply to punters and wagering providers alike. They're largely duplicated in Victoria, South Australia and the Territories, although the Victorian provision does not extend to inside information. The provisions that contain the Queensland Code are somewhat similar, but they also include the disclosure of information cases. Neither of West Australia or Tasmania have specific match offences, and as we considered the matter in the review, we thought it was important to address this, because there is a lack of harmony. The individual acts are different in various respects, although sometimes not in major respects, but this is important, and we thought it appropriate for there to be a national law, because the activity involved in a betting-related fix will commonly cross borders, with the event in one state, the conduct of the participants who are placing the bet or accepting the bet in different jurisdictions. Indeed, some of it may happen overseas. The game may be played overseas. So we think it was very important to do that. But the next difficulty with the effective prosecution is more of a practical nature, arising from the necessity for law enforcement to rely heavily on intelligence-based inquiries, which require, therefore, the positive monitoring of suspicious betting activity and a ready exchange of information which is available to NSOs, national sporting organisations, wagering providers, whistleblowers and so on. To some extent the groundwork is in place, but there are problems in this area, particularly because the information often does remain in silos. Sometimes the sports organisations or the wagering providers will not communicate, either because of concerns in relation to privacy or secrecy laws, or because of commercial or client confidentiality, or even reputational protection. So this is an area where the NSIU, the National Sports Integrity Unit, working with the Australian Crime Commission, has provided a lot of very positive work. One of the areas which I'll come to a bit later has been working with through what is called the SITAM process, where the risks across individual sports are carefully assessed, which provides therefore an area which might be subject to a target. But what we thought is critical in this area was that there needs to be a lot more done to implement a coordinated response to sports integrity issues across the country. Perhaps apart from that, the difficulty or the ability to have covert operations in this area, I think, is probably well illustrated by the News of the World sting in relation to the 2010 Pakistan-England Test match, where certain players in the Pakistan team agreed to bowl a certain number of no balls in a given time. Without that sting, it would probably never have been discovered. The bowlers certainly didn't think they'd be caught. The umpires thought it was there's nothing wrong with it, but you did need a sting and therefore capacity for covert operations to be effective in this field. The next area where we saw problems was in the regulation of sports betting. Sports betting in this country has evolved in a very uncoordinated area where I suppose the basis really depends on what's contained in the Victorian Gambling Regulation Act and New South Wales Betting and Racing Act. Effectively, those provisions permit the approval of betting markets for designated sports, both in relation to outcomes and contingencies, where those outcomes or contingencies are agreed between the approved and licensed wagering service provider and an approved NSO, and they have to become parties to an integrity and product fee agreement. The integrity part of the agreement requires those bodies, the sporting organisation and the wagering providers, to share and disclose information and concerns about suspicious activity. The product fee entitlement means that they are entitled to a product fee based on the turnover from that betting. However, there is very much a lack of a consistent system across the country, and we saw that as a very important matter which needs to be sorted out with a national sports wagering scheme. So the road to reform really began, I guess, in 2011, when the Australian sports ministers confirmed their commitment to a national policy on match fixing. And much work has been done in that area, as I said, through the National Integrity of the Sports Unit and the ACIC, but much more has to be done to carry that forward. And that's one of the reasons why we received that reference to conduct that review. Now, a key recommendation of the review, and I suppose the first recommendation of importance, was the establishment of a national platform to continue the work which has been conducted so far, and for Australia to join the Melbourne Convention. There are a number of reasons for that, but that Melbourne Convention expects the parties to it to identify a national platform for their country with a neutral framework to address the manipulation of sports competition. Australia had been involved in the drafting of the Melbourne Convention, and as a consequence, even though not a European country, obviously, it was able to join the convention, and we became the 32nd signatory on the 1st of February this year. The benefits of joining the Melbourne Convention are severalfold. First of all, becoming a party permits an exercise by the Commonwealth of the constitutional external affairs power to enact the legislation that we saw necessary. It also demonstrates an adoption by Australia of a commitment to address sports manipulation, and it paves the way for Australia to work together with the other countries who are parties, including in the working parties which are moving it forward. A second key recommendation then was the establishment of Sports Integrity Australia. This was intended to take over the role of a national platform under the Melbourne Convention, and it is to be badged, as I understand it, the Sport Integrity Australia. A bill has been introduced into the House to carry the recommendation further, but a two-stage process is involved with that body, including utilising the integrity functions of the several agencies which are involved in this space, namely the National Integrity Sports Unit, Australian Crime Intelligence Commission, ASADA and Sport Australia. So bringing those functions together I think will give us a very good coverage of the various areas and achieve what I thought was lacking, both in relation to the inquiry I did into child protection, but also in this area. The second is then to develop a potential role of that body in overseeing and coordinating the regulation of sports wagering in Australia. So a number of benefits do occur from creating this national body, including providing it with a proper legal foundation, because the NISU does not have a corporate or statutory existence, and to invest in it with appropriate legislative powers. It can carry on the valuable work of the CITAM process, which I previously mentioned, in carrying out assessments of individual sports for their integrity risks, and assisting sports, particularly smaller sports, in developing their codes of conduct in relation to match fixing, doping and otherwise. It could be able to work with major professional sports in dealing with illicit drug use and supply issues, and provide outreach to other sports, as well as providing for a dedicated whistleblower service. Australian sports wagering schemes, I mentioned, is something we thought was very important to come into being, but it is going to be a work in progress. But amongst other things, it will have the capacity, if carried out as proposed, to declare national sports organisations as sports controlling bodies and wagering providers as sports wagering service providers, with eligibility thereafter to receive product fees and to offer sports betting markets, to determine and publish a schedule of authorised wagering markets, identifying contingencies following appropriate risk analysis and consultation and collaboration, to establish a suspicious activity alert system, and to provide, by way of a central clearing house function, the ability to disseminate information between law enforcement, sports bodies, wagering providers and others. It would bring together a significant body of expertise. I've mentioned the desirability of having a national match-fixing offence, so can I just complete this address, because I do want to leave room for questions. In relation to our final recommendation of creating a national sports tribunal, this we saw as quite important, because the reality is at the moment the way in which sports disputes between sporting bodies and athletes or support personnel, or between two or more sports people, has become very topical, and their current arrangements can be dilatory and very expensive depending on the route which is followed. The government has accepted the need to establish this tribunal on a 2-year trial basis, and bills have been introduced into Parliament for that purpose. But as I've indicated, the issues which have arisen in this area recently have included, for example, the social media comments in the Israel Folau case. That was dealt with, obviously, at first instance by the ARU internal tribunal on a code of conduct violation basis, but it now appears headed to the Fair Work Commission under the Fair Work Act, and eventually maybe to the Federal Court. The alleged criminal activity in the Jack de Belin case, in which the NRL no-fault stand-down rule was challenged in the Federal Court as an unlawful restraint of trade, unsuccessfully at this stage, but although it's subject to appeal, as I understand it. And again, cases such as the Casta Semenya case involving the attempt by the IAAF to restrict her participation in some events unless she reduced her testosterone levels, a matter which began in the CAS, but Courts of Sport Arbitration for Sports, but which has moved on to the Swiss Federal Tribunal, and obviously has a great significance and relevance for athletes with differences in sexual development, and also in relation to issues about classification and selection generally. The position in Australia, as indicated, has been complicated by the fact that while the major sporting bodies do have internal disciplinary or dispute tribunals, in some cases appeal tribunals, there is no consistency across the codes, and certainly most of the smaller sports don't have that capacity. It was in the light of the desirability for sports disputes to be resolved expeditiously without undue expense that we thought it necessary and desirable to create a national sports tribunal. As proposed, the tribunal would be an independent statutory tribunal, would exercise powers of private arbitration, it would be timely, cost-effective, with funded providing in part by government and in part on a user fees basis. It would provide, hopefully, consistent and transparent decisions, and would operate with a panel of preeminent arbitrators who are appointed to the panel with expertise both in sports medicine and sports law. establishing hopefully a body of considerable expertise and experience, but also, and very importantly, having a total independence. In some cases, it's become plain, and I think you'll know the case I'm talking about, that the particular sports people who have been caught up in these tribunals have expressed a lack of trust in the internal or sports-related tribunal, and therefore have taken their case elsewhere. I think that's a sad situation, but having a national sports tribunal which is truly independent can remove, hopefully, that kind of concern. Also, this tribunal would have a capacity to employ alternative dispute resolution strategies, including mediation, conciliation and case appraisal, but only in relation to cases in the general division. The details are still being fleshed out, or they have been fleshed out substantially in the bills which have been presented to Parliament. But basically there are three divisions proposed: an anti-doping division, a general division and an appeals division. The bill is complex, but the anti-doping division has to operate in a context in which the anti-doping policies of a sporting body must be approved by the ASADA Chief Executive Officer under its legislative framework. Where the ASADA CEO approves a sporting body with its own internally run tribunal for anti-doping cases, that tribunal will maintain its jurisdiction. The other sporting bodies, however, the tribunal would become the default option. And that is, of course, where the sports body's constituent documents permit. The general division will be able to deal with all other sports disputes, both between persons and a sporting body and between two or more persons, again, where the constituent documents of the sport permit or where the respective parties agree. It was not anticipated that this division would deal with on-field incidents that would not amount to a breach of sports or integrity policies or minor behavioural issues that can be dealt with at sport level, or indeed with commercial disputes or disputes about employment that are best dealt with by the civil courts. Although I do see room for some of the employment type issues to be brought within the tribunal where the parties agree. The appeals division, well, I suppose it suggests what the title suggests. Where the anti-doping policy of a sport provides that the tribunal is the first instance for anti-doping matters, or where the sporting body, the athlete and ASADA agree, the tribunal, for the tribunal to conduct a first instance arbitration, then appeal will lie to the appeals division. However, as the World Anti-Doping Code does require that certain bodies such as WADA, relevant international sports federations and national level athletes have a direct right of appeal, that right will not be shut off. Otherwise, appeals will lie to the appeal division for matters determined by the general division. I do hope that this tribunal will get work and that over 2 years will prove to be worthwhile. Time will tell.